So, today I want to talk about anti affirmative action propaganda. On Halloween, the Supreme Court listened to the arguments for two affirmative action cases, one against Harvard University and one against the University of North Carolina. Now, in both cases, the plaintiff was the same, an organization by the name of Students for Fair Admissions. This organization has more or less devoted itself to preventing universities from taking racial or ethnic background into account during admissions, essentially advocating for a supposedly race neutral policy. However, this type of supposed race neutral approach has historically not worked at all, and has actually led to more racist and less equal outcomes. Pretending that race doesn't exist in a system that has historically upheld and provided benefits to certain populations doesn't lead to equality. We cannot simply look at individuals without taking into account the lived experiences of people and the cards that they were dealt through historical and systemic injustices. Additionally, this asks universities to completely ignore ethnicity and cultural identities of a person when evaluating them, something that's nearly impossible to do, especially when one's culture often influences huge aspects of one's life and personality. The truth is that evaluating an entire person means taking their race, socioeconomic status, culture, ethnicity, and their accomplishments into account to view the wholeness of a person. Otherwise, the end result of these types of supposed race neutral policies usually leads to a significant whitewashing of institutions that already has a significant bias towards white people and power structures. That said, the way that the SFFA has approached these two cases is a little different from the standard race neutral approach, and their tactics come across as incredibly slimy. Instead of arguing directly for a race neutral approach, they have made the claim that universities are discriminating against Asian American students through affirmative action policies, something that could not be further from the truth. This propaganda tactic makes it look like they are upholding and defending the rights of minority populations, rather than breaking down a system that has historically been the only reason that some of these universities ever accepted non white applicants in the first place. Now, unfortunately, this tactic has been not exclusive to the courts, and adjacent organizations have been pushing this narrative in the media to try to sway public opinion in a way that paints them as heroes. So let's take a look at one such example from The Hill, where it starts off 100 years ago on November 13th, 1922. The US Supreme Court held that an Asian man could not become an American citizen because of his race. 2 weeks ago, the Supreme Court considered whether universities can exclude Asian students because of their race. History does not repeat itself, but it does rhyme. So, what the author of this article attempts to go on to do is to compare the case of Ozawa v. United States to these present cases by claiming that both sets involve the systemic exclusion of Asian Americans through the process of discrimination. However, the Ozawa case and these two present cases are not even remotely comparable, and they are the embodiment of a false equivalence. For those that may not know, Ozawa v. United States was a Supreme Court case that denied a Japanese immigrant citizenship because Japanese people were not white in the eyes of the law. At the time, naturalization laws in the United States only applied to, quote, free whites and, quote, persons of African nativity or persons of African descent. This ruling was an application of white supremacy through the racial discrimination of someone who could never be white enough and therefore not be a citizen in the eyes of the United States, no matter how much they assimilated. Now, the article does attempt to explain this case in their own terms and in a way that is meant to provide a clarification for their arguments, as wrong as they might be, and then goes on to claim 100 years later, after the Ozawa decision, two American universities are trying to convince the court that applicants' race matters. Students for Fair Admissions, the petitioners who brought the cases against the University of North Carolina and Harvard, argue in a brief that a person's skin color has nothing to do with who they are, what they think, or where they've been. Except it does. And the fact is that the story of Ozawa actually proves just that. Japanese people like Ozawa were not citizens, and therefore often could not purchase land or even lease land to grow crops on. In fact, thousands of acres were seized from Japanese immigrants and sold to white farmers. That doesn't even touch on those who were placed in internment camps and had their livelihoods and businesses stolen from them. They did not have the historic advantages of white counterparts, who were literally systemically placed in a position where they could accumulate more wealth and resources, as well as attain access to college and universities that much earlier. The story of someone whose grandfather was in an internment camp looks very different from someone whose grandfather was serving in the US Army and got access to the GI Bill to get free housing from the government in the new sprawling suburbs. Now, when we look a little further into this, we actually see that the NAACP Legal Defense Fund actually points out that for almost 85% of its nearly 400-year history, Harvard systematically excluded Black, Latinx, Native/Indigenous, Asian American, and other students of color. Affirmative action stands on the side of Ozawa to push universities towards a practice of combating white supremacy and recognizes race as a means of understanding the historic advantages provided through institutions of white supremacy to white people, especially forms and institutions like the Supreme Court. Now, when we consider a little bit more information, we find that with affirmative action, Asian Americans actually rose from 3% of the class of 1980 to 27.6% of the class of 2026. Asian Americans are an extremely economically diverse group. Many Asian Americans face great adversity and have fewer educational opportunities before applying to college. If admissions were based strictly on test scores, about 20% of Asian Americans attending elite colleges would not be admitted at all. Additionally, when affirmative action has been ended in universities, we have seen a sharp decline in students of color. For example, at the University of Michigan, we have that in the past 16 years since they eliminated affirmative action in their institution, the percentage of Black students at the university has decreased from 7% to 4%. The percentage of Native American students dropped from 1% to 0.11%, nearly a 90% reduction. And when the practice ended in California, the state's most selective campuses saw minority enrollment drop more than 50%, and earnings fall for Black and Hispanic graduates. And at the University of Oklahoma's largest campus, the number of Indigenous freshmen fell 11% in a single year, despite the state being home to one of the largest Native American populations due to their own historical and systemic injustices. So, no, the claims that are presented in this article are false. Asian Americans are not getting discriminated against through affirmative action. In fact, the only group that has benefited historically from affirmative action not being in place have been privileged white people. Which, to me, brings up a question for the Hill. How did they allow this inaccurate so-called opinion piece into their paper when it's so factually wrong? Further, what was the author's intent to get this published, and what are they hoping to accomplish with this propaganda piece? Well, for the first question, I'm not going to necessarily be able to get an answer from the Hill. But when we look a little bit more into the author, we can find some information. The author of this article, Nicole Yeatman, is a managing editor at an organization called Pacific Legal Foundation, a nonprofit legal organization that claims to defend Americans' individual liberty and constitutional rights. This very same organization actually filed a friend of the court brief on behalf of the SFAA, meaning that the Hill article that we examined is propaganda for the case. And to make matters worse, if we look more into the history of the SFAA, we actually find that the SFAA is an organization led by an anti-civil rights activist, Edward Bloom. Bloom has participated in numerous cases that have led to the destruction of civil rights legislation, including Shelby County versus Holder, where the Voting Rights Act was gutted. Additionally, we have that Bloom had previously enlisted white students to sue over race based admissions at the University of Texas and lost. So this time he switched tactics, using Asian Americans to accomplish his ends and goals. In fact, according to John C. Yang, president and executive director of the nonprofit Asian Americans Advancing Justice, Asian Americans and Pacific Islanders have been used as a wedge, and certain groups have purposefully showcased Asian American descent to affirmative action as a way of masking their anti Black and anti Latino agendas. Such efforts hide the fact that most opponents of affirmative action are really trying to increase the number of Caucasian students at the expense of Black, Latino, and Native American applicants. Bloom and the SFAA represent the same type of people who would have fought against Ozawa's citizenship in 1922 and continue to fight against civil rights legislation for people of color. Far from being the supporters of individual liberty and acknowledging the whole of a person, they represent a false race neutrality that upholds white supremacist structures in a system designed and created for white supremacy. They may have changed their tactics, but the goal is the same. That said, the court's decision is unlikely to be made official until June. However, the current Supreme Court, with its 6 conservative justices, will likely strike down affirmative action in these 2 cases, as most of the judges seemed actively hostile to affirmative action during the hearings. These 6 authoritarian judges will be able to make it that much more difficult for colleges to remain a somewhat equal playing field, which will of course impact wealth and education in communities of color for decades to come. Further, this will end up having significant implications in the long run, not just for universities, but for any program that specifies race in a way that is assisting people of color. This could include employment and grant programs as well. The goal of Bloom, the SFAA, and the Supreme Court is quite clear in these cases. If you just look under the surface of their slimy veneer, you can smell the scent and see the burning desire for them to recreate a white supremacist institution and take away any sort of ability and potential remedies that we've seen for people of color over the past 50 to 100 years. So with that said, if you've learned something here today, consider liking the video, subscribing, and leaving a comment, as well as joining my Discord. If you're in a financial place to do so, and only if you're in a financial place to do so, please do consider supporting me on Patreon, especially as it goes a long way to supporting this channel. The links for everything that I mentioned are in the description down below. With that said, my name is Anarchist Tara. Thank you so much for watching.